Well, hello, I'm Professor Ben Richardson from the Faculty of Law at the University of Tasmania, and I'm looking forward to giving you this lecture now on protest and anti-protest law in Australia with some regard to Tasmania. I'm going to speak for about 30 minutes, and you'll have an opportunity to ask me some questions when there's the question and answer panel that will be held in early September. The topic that I'm going to talk to you about has been in the news a lot, not just in Tasmania, but around Australia and indeed around the world. The COVID-19 virus has certainly dominated global news in the year, but the pandemic hasn't stopped many activists protesting on grievances like climate change, the environmental crisis, racism and other concerns. Australia, as in many countries, has experienced mass protests, for example, from the Extinction Rebellion movement, the youth climate strikes associated with Greta Thunberg, the Black Lives Matter rallies, among many examples. And the recent huge bushfires last summer in Australia triggered mass protests from many demanding that our governments take more action to prevent such disasters. Now, environmental protest has been a feature of Australian politics for many decades. In the 1960s, protests started to become more frequent when people started to realise that they had to take to the streets to stop proposals for mining in the Great Barrier Reef, to clear the Little Desert National Park in Victoria for wheat farms. And in Tasmania, we had a dispute over Lake Pedder, which was ultimately destroyed by a hydropower dam. And at that time, there were virtually no laws in place to stop such environmental destruction, nor did the general public have rights to have a voice to express their concerns. And so the only option, therefore, was to take to the streets and protest. Now, the modern era of environmental law, which began in the early 1970s, has brought many benefits to Australia. We've got cleaner air and water as a result of pollution control laws. We've got many more national parks. And these laws also provide opportunities for public participation in decision making, thereby channeling protesters off the streets into administrative and judicial forums where governments hoped that they would be able to appease or to diffuse the grievances of the general public. So we had laws, for example, in New South Wales, such as the Environmental Planning and Assessment Act of 1979, the Land and Environment Court Act of 1979, which gave broad rights for public participation in decision making, enabling people to be consulted and heard before decisions were made, and after decisions were made to have access to the courts. Now, the failure of these laws to cope with a new generation of environmental upheavals, for example, climate change and marine plastic pollution, has become apparent with the unleashing of a new wave of activism and protest. Global carbon emissions, for example, have continued to grow in recent decades, despite international agreements and national legislation that ostensibly aims to mitigate climate change. So there's a heightened sense of urgency among many that time is running out for bold action on environmental issues. Yet governments in Australia controversially continue to approve major fossil fuel projects, such as recently the huge Adani coal mine in Queensland, which is bad news for those who care about climate change. Now, with our parliaments, courts sometimes failing, therefore, to embark upon the necessary environmental law reform, many people are again going back to the streets to protest, to lobby for better laws and to stop developments. On the 17th of September 2019, the illustrious science journal Nature included an essay written by Extinction Rebellion climate activist and lawyer Farhana Yaman, who had broken the law by supergluing her hands to the street pavement outside the headquarters of the oil company Shell in London in the United Kingdom. And she was arrested for criminal damage. And she wrote in the journal Nature, the following: having spent 3 months failing to get governments to pay attention to the climate crisis through advocacy at the highest levels, I felt that activism was now crucial. I wanted to show how ridiculous it is that a law-abiding and indeed law-making mother of four should be handcuffed while the world's major polluters remain unaccountable for ecocide. Ecocide being a phrase that some use to describe crimes against the environment. So this shift is epitomised strongly in the Extinction Rebellion movement, which is also active here in Tasmania, whose members are seeking to block traffic, stage mass die-ins where people are lying on the ground, for example in a shopping centre, disrupting public transport in the hope of overwhelming law and order authorities and compelling governments to act and take seriously their message. Mass rallies, particularly the climate strikes in September 2019 that swept many cities worldwide, including Hobart, represent another dimension of this new activism, involving tens of thousands of participants, including many school children. In Hobart, the rally attracted 22,000 people, which is about 10% of Hobart's population. Aboriginal people have also been protesting and taking to the streets, such as opposing coal mines and other major developments on their land. And recently we've had Aboriginal people involved in the Black Lives Matter rallies around Australia. Now these are gaining media publicity and they're helping to convey the public anxiety about looming climate breakdown and social injustices in the hope of catalysing positive action. So what I want to examine further in this lecture here is the rights that Australians have under the law to engage in political protests and some of the legal restrictions to that activism. And the topic may be of direct relevance to some of you listening to my lecture, given the growing involvement of school children and youth in some of these rallies and protests, particularly around climate change. So let's look at the right to protest, why it's important. The right of people to engage in protest, whether it be over political issues or workers striking for better pay, better employment conditions, has been important for the functioning of democratic societies for many, many years. Creative civil disobedience has succeeded in the past. For example, the suffragettes campaigned over a century ago for women to earn the right to vote in elections. Gandhi in India fought using civil disobedience to secure India's independence in the 1940s from Great Britain. And the Black Civil Rights Movement in the United States was a protest movement in the 1960s and since then, which had a lot of success. Now, Australian courts recognise that there's a valuable role to be played by social protest. An important decision from the High Court of Australia in 1982 is the case known as Neil versus the Queen being representing the Government of Australia, in which an Aboriginal man appealed to the High Court against the severity of a 6-month imprisonment that he was given at a lower court for spitting at a white person. Now, the context of this dispute was that there was racial tension and prejudice against Aboriginal people in this community in Queensland. Now, Justice Lionel Murphy of the High Court of Australia referred to the lower court magistrate's characterisation of Mr. Neil as an agitator. And Lionel Murphy said, to quote him, and this is from the court judgment, "If he is an agitator, he is in good company. Many of the great religious and political figures of history have been agitators, and human progress owes much to the efforts of these and many who are unknown. As Oscar Wilde aptly pointed out, agitators are a set of interfering, meddling people who sow the seeds of discontent. Without them, in our incomplete state, there would be no advance towards civilization. Mr. Neil is entitled to be an agitator." Now, agitation has leveraged quite a few successes in Australia in recent decades. For example, the protection of the Franklin River from a monstrous dam in Tasmania in the early 1980s is an example. The returning of stolen Aboriginal land to Aboriginal people is another example. And protests about improving the legal status of gay people. Now, this legal entitlement of people to protest flows from them having the rights to assemble, to organise and to speak in public. And these are rights which are recognised in international law, laws that Australia has approved. The International Declaration on the Rights of the Declaration of Human Rights of 1948, the International Covenant on Civil and Political Rights of 1966 are among examples. For instance, the right to engage in participatory democracy without unreasonable restrictions is explicitly acknowledged in Article 25 of the International Covenant on Civil and Political Rights. But international law itself generally has no direct application in Australian internal law unless that law, the rights, the duties, have been incorporated into Australian law through, for example, parliamentary legislation or court rulings. Now, Australia lacks any explicit human rights in its national constitution, unlike some countries, for example, the United States and Canada. Nonetheless, a right of freedom of communication about political and governmental matters has been interpreted by our courts as existing in the Australian Constitution. So even though it's not expressly written in the Constitution, the courts say that that right is implied because freedom of communication, say the courts, is essential for the maintenance of the system of democratic government that our Constitution does provide. In other words, a democratic system in which citizens vote for political parties to form government can only work if people have the right to freely express their views on political matters. And political communication includes non-verbal communication, assembly and movements for the purposes of political protest. Now, this implied right of freedom of communication on political matters operates as a limit, but not a complete bar on legislation that would attempt to restrict freedom of expression. Now, some individual states and territories in Australia have also, in addition to that implied right, passed legislation that creates specific human rights charters for people. And those rights include to speak, to assemble and to protest. The Parliament of the Australian Capital Territory, the ACT, in 2004 enacted a Human Rights Act that affirms several rights that are relevant to protesting, including freedoms of movement, expression and assembly. The legislation, however, provides that such rights can be subject by the ACT Parliament to reasonable limits that can be demonstrably justified in a free and democratic society. Queensland has also passed a similar law, the Human Rights Act, which took effect on the 1st of January of 2020, and it affirms 23 human rights, including rights to freedom of expression and peaceful assembly. And the legislation obliges courts and other public authorities to interpret all Queensland laws, as far as possible, in a manner consistent with those human rights. And thirdly, Victoria has passed a human rights code. It did so in 2006. It's called the Charter of Human Rights and Responsibilities Act. And it too establishes basic rights for Victorians to assemble and speak as mechanisms of protest. And again, those rights, as in the other two examples I just mentioned, do not provide unlimited authority to protest. And they can be restricted, according to the Charter, for the protection of national security, public order, public health and public morality. Tasmania does not have any such human rights laws that explicitly allow Tasmanians to assemble, hold rallies and engage in protests. So let's now turn to look at the kinds of restrictions that the law might place on the right to protest. It should now be clear that no right to engage in political protest is ever unlimited or unqualified. Human rights are exercised in consideration of the rights of other individuals and wider societal interests, thereby requiring some trade-offs or limitations. Now, in Australian law, a variety of considerations may result in restrictions being placed by parliaments or courts on the right to protest. These could be, for example, to prevent obstructions to vehicles or pedestrians on streets. There could be laws restricting protests in the name of protecting national security. Thirdly, to maintain public order and safety. Fourthly, to safeguard property rights. And finally, to minimise nuisances to other people. So there's some of the reasons why laws might restrict people's ability to go out and engage in protest actions. Protests in Australia can generally be undertaken lawfully on public land, as well as private land into which the public has unrestricted access. However, one cannot protest where access to a place is obviously restricted. For example, if there's a gate or a fence that says trespassers keep out. Now, under the law of each state or territory in Australia, if a group or individual wishes to stage a protest on a street or other public place, it's often the case that they will need to obtain an official permit from the local police station or from a local government authority in the relevant area. And if it's issued, it would contain certain conditions, for example, about the route of the protest march, the time, and the sort of behaviour. Now, if such a permit is granted, then participants in the protest who observe the conditions in the permit will be exempt from any possible criminal offences that otherwise might apply, so long as the protesters behave peacefully. If protesters don't have a permit in a situation where they do, they may be prosecuted by police for a variety of offences. These could include blocking traffic, disrupting public order, damaging property, for example, if bus stops, traffic lights or other road-related infrastructure was to be damaged. Failing to move on, police may arrive at the scene and tell protesters to move on, to leave. Failure to do that would itself create an offence. Trespassing is another possible offence. This would be applicable, say, on a private road, for example, on the land that's under the control of a mining company, as well as on some sensitive public lands, for example, at a military base or an airport. There could also be, currently with the COVID-19 pandemic, there could also be violations of public health regulations that require people to maintain physical distance and not to be involved in travel for non-essential purposes. And that certainly would be the case in Melbourne at the moment. Many of these offences operate on a strict liability basis. What that means is the police would only need to prove that one had engaged in the conduct to establish that you're guilty without needing to demonstrate the intention of the defendant. In other words, to look at the state of mind of what someone was aiming to do. These offences are typically known as summary offences as against indictable offences. A summary offence is tried by a judge alone, usually by a local magistrate. An indictable offence, by contrast, would be a much more serious offence where there's a trial by a jury of one's peers. The penalties for these summary offences would commonly be a fine, and it could be somewhere between a few $100s up to a few $1,000s. And in theory, it could even be imprisonment for maybe up to 6 months, although that would be very rare and usually only in extreme cases of bad behaviour. Guilty offenders may get a criminal record, although not if it's someone's first situation where they've had a brush with the law. Depends on the views of the magistrate. It may also be that a judge, rather than imposing a fine, imposes a probation on the offender, saying that no punishment will be imposed so long as you remain in good behaviour, with no more incidents brushing with the law, interacting with the police for the next number of years. It's also possible that a magistrate could impose a community service order against a guilty protester, and that could be in order to spend time in the community cleaning up rubbish, helping with a charity organisation, to illustrate. Now, an important legal development in some parts of Australia in recent times has been the introduction of laws that make it more difficult to be a protester. These are anti-protest laws, and they've been developed and adopted in New South Wales, Tasmania and in Queensland. And they've been criticised by lawyers and civil liberty groups as providing for overly broad police powers for very vague offences. In other words, the conduct that gives rise to offence has been framed as rather vague, and the penalties are often very severe and sort of disproportionate. And it's been interpreted that what these governments are more interested in doing is protecting the interests of businesses from being disrupted by protesters, rather than the rights of individuals to peacefully protest and raise legitimate political matters. One particular example is in Queensland in late 2019 adopted a law that bans lock-on devices in the context of a protest. These have been used in some blockades recently where protesters chain themselves to gates or fences, with violations incurring penalties of up to 2 years plus fines. Lock-on devices are problematic because they can tie up police resources for many hours, as special equipment may be needed to cut out chains or gates to which a protester is locked on. In New South Wales, there's also been the adoption of some new laws that have increased fines for protesting actions associated with mines by 10 times, along with up to 7 years jail for anyone who's been hindering the use of mining equipment. The COVID-19 pandemic has also given governments an additional tool under the guise of public health regulations to restrict public gatherings or non-essential movements. For example, recently in Sydney, a Black Lives Matter rally was banned by a court after the police sought an injunction to stop the rally going ahead because of the perceived threat to the spread of the virus. Nonetheless, courts sometimes may not uphold these anti-protest laws because the courts believe that the competing right of the ability of people to communicate on political matters is more important. This happened in 2017 when the High Court ruled that some elements of Tasmania's anti-protest law, which is known as the Workplaces Protection from Protesters Act of 2014, was invalid because it went too far, according to the High Court, in restricting the right of freedom of political communication implied in the Constitution. Now, I want to talk a little bit about Tasmania's laws and protest laws. Tasmania lacks any legislation explicitly regulating peaceful assembly, unlike legislation in other Australian jurisdictions. It does, however, have the anti-protest legislation that I've just mentioned. Public protests in Tasmania on roads are illegal without a permit. It's okay to hold a protest event, for example, on the lawns in front of Parliament House, and you'll often see those. But in other contexts, where public traffic and convenience is to be disrupted, a permit would be needed, and that would be obtained from the local police station. Under the Police Offences Act of 1935, it is an offence if a person stages a rally or march or protest on a street without a permit. In addition, that legislation creates certain offences that might be created by a protest. For example, if it causes disorderly, riotous conduct, it creates a nuisance. And there are penalties there of up to $4,200 for an offence or up to 6 months imprisonment. More serious offences with heavier penalties in Tasmania are possible under the Criminal Code Act of 1924. For example, if there was to be an unlawful assembly that involved a riot that caused alarm for reasonable people and breached the peace, that would be an offence under Section 73. Under Section 140, there could be an offence of creating a common nuisance that endangers the health, safety, property, or comfort of the public. And punishment can be quite severe under the Criminal Code, up to 21 years imprisonment and or a fine, although that would be very rare in the circumstances we're talking about. In addition, there's Tasmania's Workplaces Protection from Protesters Act of 2014, which targets protesters who disrupt businesses, and it extends not only to behaviour on a business, but to an area where there is access to a business, for example, a road. And the Act prohibits people from engaging in actions that would hinder or obstruct access to those wanting to get to that business. Tasmanian authorities have also used the COVID-19 regulations to prosecute anti-logging activists. At an earlier phase in the lockdown in Tasmania, there were some activists who went to some of the logging coops in the forestry areas of Tasmania, and they were breaching the rules about non-essential travel, and so that was being used against them. If one is arrested or charged by police and you're a protester, there are some additional legal issues that I want to mention that happened in Tasmania as well as all jurisdictions. Someone who's arrested has a right to remain silent. apart from giving one's name, birth date and address if asked by police. One is also entitled to know the reason why one has been arrested, so police have an obligation to tell you that. You also have a right to telephone a friend, a family relative or a lawyer. And before a police officer can start questioning a protester who's been arrested, the officer has to give a caution that the protester does not have to say anything. And if anything is said, it could be used in court against him or her. Police may also search a person who's been arrested without their consent if they believe that one has objects or materials that are relevant to the commissioning of an offence, for example, a lock-on device. And police can also ask protesters to remove face masks. There are special considerations in the law that I won't go into, but they would be applicable to someone who's under the age of 18 years of age. For example, that person's parents would need to be called probably. And for persons who English is not their first language, if they don't communicate fluently in English, there would be, for example, a requirement to get a translator. Now, in a couple of cases in Australia that have gone to court where people have been protesting against climate change, some protesters have tried to argue in court that there is a defence to their action, which is known as the climate emergency defence. It's based on the idea that one is engaging in civil disobedience, in other words, protest, in a way that's justified, even though the law is technically broken. The law itself provides an excuse for breaking the law when it's necessary to speak out and promote action against a larger evil, the larger evil being the climate change crisis. Now, the first court case in the world to acknowledge the climate emergency as a defence to criminal conduct was in 2008 in England. 6 Greenpeace activists were charged with £30,000 of criminal damage at a coal-fired power station, which they'd sought to disrupt by scaling its chimney to place graffiti, shaming the then UK Prime Minister Gordon Brown. The jury who heard the case excused their behaviour after hearing evidence from a famous climate scientist that the amount of carbon dioxide being emitted from that power station every day was equivalent to the world's 30 least polluting countries and would contribute to the extinction of up to 400 species and sea level rises around the coast of England. The climate emergency defence has had mixed success since then. It's been used successfully in the United Kingdom on 2 or 3 occasions, but it has been tried twice in courts in Queensland recently by climate activists who were charged with blocking traffic, and the magistrates in those Queensland decisions did not accept that the climate emergency defence is a legitimate reason to break the law. And so those activists were given fines. One of them, Greg Rolls, was given a fine of about $7,000 because he was blocking a railway line that was used by coal mining companies. Another case involved 3 young women in Brisbane who were blocking traffic. They were unsuccessful in using the climate emergency defence argument, and they copped fines between $800 and $2,800. The magistrate refused to accept that there was any legitimate reason for their actions just because protecting climate was what was motivating them. So clearly there are some significant challenges at the moment in Australian law to be able to argue some sort of excuse for why one engages in protest actions where one doesn't have a permit and where one is subject to adverse policing by authorities. I just want to finish briefly this lecture mentioning that protests can take other forms apart from marching in the street or blocking traffic or blocking railway lines. Another form of protest is economic protest, which people use their economic power as consumers or investors to try to influence the behaviour of business companies engaged in environmentally unacceptable practices. The one example is the consumer boycott, in which consumers are encouraged not to buy the goods or services of the targeted company. For example, animal rights activists have organised boycotts against some food companies associated with practices that they allege are cruel or harmful to farm animals. Now, the success of such consumer boycotts, however, tends to be limited unless masses of consumers agree to cooperate in order to economically punish the targeted company. Another type of economic protest is coming from climate-conscious investors, for example, shareholders in companies, who are seeking to divest, in other words, to sell off their shares from, say, fossil fuel companies like coal mining companies, in the hope that they will deprive those companies of the necessary finance that they need, in the hope that therefore they'll go out of business or will change their business model. Now, under the auspices of a number of fossil fuel divestment networks around the world, including 350.org's Fossil Free campaign, as well as the Fossil Free Divestment Student Network, the campaign is targeting major carbon emitters, and mainly oil and gas companies and coal companies around the world. Universities are also involved, including the University of Tasmania, where students have been targeting the university to stop investing university money in or having any financial ties to fossil fuel companies. And certainly some Australian universities, which have sort of quite substantial investment funds, have made decisions to remove any financial ties to companies that are seen as involved in dubious environmental practices and climate change practices. Now, under the law at the moment in Australia, such consumer and investor boycotts are generally legally permissible, and they can provide useful means for protesting by environmental activists when street-based protesting is becoming increasingly restricted by the law. So that brings my lecture to a close, and I hope you've been able to understand from it the value of protest as a means of law reform and creating a better society, recognising that it's well recognised in international law, the right to assemble, to organise and to speak out. To appreciate that in the Australian context, there's a variety of legal rules that shape the right to protest. There's the constitutional implied right of freedom of political communication. In some states or territories, there are specific human rights charters, but not Tasmania. And then I've looked at some of the legislative restrictions in the criminal law that can inhibit and restrain the right of people to engage in protest, particularly if they don't have a permit. And then we've looked at the climate emergency defence as a possible legal excuse for actions that otherwise are against the law. It's had success in the United Kingdom and not Australia. And finally, I've looked at economic protest as an alternative means by which people might wish to voice their concerns about environmental concerns. Thank you for listening.